Welcome back to another edition of Impact with DBO. I will be responding to a question by one of my respondents. It has to do with intellectual property. Do I need to register to own the right to my works? It deserves my attention. So, okay, let me address it. Now, categorically speaking, you don't need to register your work anywhere at any time to own the right to the work. No, it is not stated anywhere. What you need to do to own the right to your work, there are principally two things. Your work must be original and it must be in tangible form. What I mean is, you cannot own the right to a work that is not original to you. If you have a work and it's not original to you, you don't own the copyright. And even when you have the work and it's original to you, it must be in a tangible form. It must be either written down, recorded, one way or the other. It must have left your imagination to be in a written form. The moment you do that, it becomes your right. You have the right, 100% right on those works. In the case of music, either it is written down or it is recorded. When it is written down, you have to be very careful. If a musical work is written down, that means if it is only the text, you own the copyright to that text, because texts do not make music. But if it is written down, either in sheet music or scored in sulfur notation, then you own your right. It is yours. Why people get confused is, do I need to register with Nigerian Copyright Council? I will advise it is, but it is not a condition to enforcing your right. No, it is never a condition that you must register to enforce your right. It is not done. But why it is advisable, should there be any legal tussle, then you can make reference to it that I put it down with MBC first. In those days, in the early days of copyright, what people used to do, it's when they have their work, when they put it in tangible form, they will post it to themselves. Go to post office, register it and post it yourself, so that there will be a stamp there to indicate when that work was created. That means when it becomes your creation, because that's the essence of this whole thing. The work must be your creation. So you put it there. So in case there is any infringement, you can bring it out and say, I actually registered this work on the 30th January and the date is here. Subsequently, people began to dump their works in banks. When you have made it tangible, either in written, oral, or whatever, then you keep it in a bank. But this is 21st century. All what you need to do is that when you have your work now, just upload your work. When you have your work, upload your work. It is there and it is there in your name. So if there is any infringement or any contention, you can easily make reference to when you uploaded your work and establish those facts that this is my work. So it is advisable. It is not a condition. There are two things. It is advisable. Because you did not register your work with MBC, does not actually mean you do not own copyright to your work. It is your work, as long as it is not in your imagination. Now, what I'm saying, let me explain further. If, as a friend, I express my musical composition with you, I did not put it down, and everything is, you were just chatting, and I give you the lyrics and everything, and I've not written it down. And my friend goes on to work on that job and everything, and it becomes an issue. As long as it is not in tangible form, I don't own copyright to that work. No, I don't own copyright to that work. But if it is in tangible form, I've written it down and I gave it to him and he looked at it, he worked on it, and eventually he goes ahead to record my work, then it's liable because it has become my work. It is my original piece. It has been in tangible form. Now, this issue of being original or not being original, why you need your work to be original is to establish that you are the creator. Because copyright, it's about having a right on your own creation, not another person's creation. Not another person's creation. So, for instance, if I know that you are not the creator of this work and you own the right, I can as well go and copy it. When we get to the law court, and what I just need to prove is that, this guy is not the original owner of this work. This is the original owner of this one. I've been able to prove it. And because you cannot own copyright to what is not your creation. So those are the issues. Now, back to the thing. It is not mandatory that you register your work with anybody. It is not a condition. but it's always advisable that should there be problems, should there be any legal suit, should there be any contention, you can quickly go to NBC and say, I dropped this work with you, or you can go to your bank and say, I dropped this work, or you can just check 21st century, look at the date this thing is downloaded. For instance, let's take photography. When they snap, the date is always there, that this is my own creation. So the date is there. So any subsequent copy, it can easily be proven that there's an infringement has occurred. So those are the basic issues. Although there are some other things which I'll be addressing maybe in the next edition on what you need to do. It's a little bit more than that, but those are the basic things, because there are some instances where you don't own right to the work. There are some instances where you cannot lay right to your work. We call it exemptions. I'll be talking about that in the next edition. But basically, what I've discussed today, there's no law that says you must register your work anywhere. What the law says is that it must be your own creation, then it must be in tangible form. Thank you very much.